So this is Loretta Melby, or Lori. I'm the board's executive officer, and we will be holding an interested parties meeting today for the Nurse Practitioner Advisory Committee. I will let Reza speak a little bit to open it up as well, so you guys kind of understand the ground rules here. The one big thing is that our Nurse Practitioner Advisory Committee is watching this through WebEx. They are not here on this meeting. They are watching it remotely as not to violate Bagley-Keene. And this is where our public has been invited to come in, look at what our regulation teams, both Heather Hoganson and Mariko Kotani, have created to help us with the implementation of AB 890 and provide some feedback. We're ready to hear. We're all kind of waiting with bated breath, taking notes, and hoping that we can really kind of have a robust kind of information sharing session here. So I will now open this up to Reza, and he could set some ground rules, and we're ready to start. Thank you, guys.
Good afternoon, everybody. This is Reza Pezhuhesh, the BRN's legal counsel. As far as ground rules, I think it's going to be pretty similar to public comment at our other meetings. I believe we're limiting comment to 2 minutes per person. As Lori said, our committee members are not on the line here. The main purpose of today is to obtain input from members of the public with regard to the materials that were posted and with regard to any other thoughts that anyone may have regarding the board's implementation of AB 890. The Nurse Practitioner Advisory Committee has a meeting scheduled in November. The agenda will go out a little closer to that time, at least 10 days ahead of that meeting. I believe the date is the 16th. And at that time, they'll have an opportunity to discuss amongst the committee the materials that are posted here as far as draft regulations, any input received today from members of the public, and all of that. And of course, members of the public will be more than welcome to join on that meeting as well and make more comments. I think that's about all I have. I look forward to hearing the input that those attending today are going to be sharing with us. So thank you.
Great, thank you, Reza. I'm going to actually open it up to Heather and have her introduce herself and her team.
Thanks. So what we have done here is taken a draft from the various subcommittee meetings and reports that we've been able to listen to. Mariko and I are lawyers. We're not nurses. We don't have any specialized medical degrees, and so this is a great place to start to say, hey, we didn't fully understand the nuances of X or Y. We didn't really know what to call the 103 and 104 nurse practitioners, so we've started off calling the 104s independent, for lack of a better term, but we invite ideas as to what those two groups really should be called going forward, because probably people don't want to identify themselves as a 103 nurse practitioner 5 years from now. The regulatory draft product that we have in front of you, it's just a draft.
So real quick, Heather, sorry to interrupt. Right now we're on the call to order. So it would just be introducing yourself and Mariko, and then when we get to that agenda item, I'll have you go into that. But I don't want to.
I heard introduction and I was like introducing the text. Sorry. No problem. We are not subject matter experts, but we are regulatory experts, and so if you have process questions, we'll also be here for that. So with that, I'll turn it back. Thank you.
Thank you, and then we'll open it up to Mariko to introduce herself.
Tani, I'm Heather's colleague at the DCA. As she mentions, we are attorneys. not nurses, so we welcome all of your expertise and input, and I am looking forward to hearing what everyone has to say and offer today. Thank you.
Thank you. So Mark, we can go to agenda item 2.0.
Good afternoon. This is the BRN moderator. I will be moderating the meeting. To facilitate public comment, we will be utilizing the WebEx question and answer feature. When the committee reaches the point in the agenda at which public comment is appropriate, the question and answer feature will be turned on and members of the public can indicate that they would like to make a comment by inserting the phrase, "I would like to make a comment," in the question box, which is typically in the lower right of your screen. I will then call on the individual and unmute their microphone. The individual will have 2 minutes to make their comments. I will not give a warning as your time approaches. I will mute your microphone and will announce that your time has exceeded the time allotted. I will then move on to the next member of the public who has a comment. Please note that the question and answer feature is being used only as a means for members of the public to represent that they would like to make a verbal comment. This is not a means to ask questions of the moderator or members of the committee. Such inquiries submitted using this feature will not be answered. When asking a question, please make sure the question is directed at the host, me in the dropdown. Lori, is this different for this meeting? As far as
No.
question, no, there it's this. Oh, so this is informational, but not. Got it. Okay, I did hear that.
I mean,
Sorry.
we can obviously have discussion if it's on topic for the agenda. Reza or Heather or Marco or myself can go ahead and respond if it is pertinent, but
okay, perfect. I could remember hearing General share. Okay, gotcha. Okay, if any attendees utilize a profane name, they will not be called upon to prevent members of the public from being subject to profane language. While you are free to express criticism or negative views, for the sake of the members of the public participating on this call, please do not use profane language when making public comments to the committee. I will provide a brief reminder of this approach at the start of each public comment item. Finally, when committee members or senior staff are not speaking, I would like to remind them to mute their microphone. If I detect background noise during the meeting as a result of unmuted microphones, I will interject with a brief friendly reminder.
Okay, thank you, board moderator. So 3.0 is the agenda item for public comments, not on the agenda items for future agendas. So we can go ahead and open this up at this point, board moderator.
Gotcha, 1 second here. Whoa.
Opened up. This is Reza. I'll just make a couple quick comments. This upcoming agenda item, just to reiterate, is for items not on the agenda. We will, of course, be, after this item, proceeding to discuss AB 890. So if you have comments related to AB 890, you may want to hold them until the appropriate time a little bit later on. Also, just to set expectations, the primary purpose here is to obtain input, and as Heather and Mariko said, to obtain input from members of the public who may have a lot of very valuable subject matter expertise and just general very valuable insight here. But the primary purpose is not here to be a question and answer type session. So I would ask that, unless it's kind of a rare thing that may be appropriate, to provide comment rather than questioning those on the panel here today.
Okay, we will be opening for public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in the request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." 1 second.
Board moderator, this is Lori, the executive officer, and I did notice that people did put in that they would like to make a public comment. And these are, again, just to reiterate, these are items that are not currently on the agenda. So if this is a comment regarding the implementation of AB 890, sections 101, 103, or 104, those will be discussed in the appropriate agenda items. So we welcome all others, but please, again, refrain from doing public comment now on the implementation of 890s, sections 101, sections 103, and section 104 until we get to those agenda items. Thank you.
Stephanie Dittmer. Oh, sorry.
Before Ms. Dittmer goes, I just one additional quick thing, pretty minor, but I think it's stated in the materials that it is helpful to identify yourself, and if you're with an organization, to let us know the organization. That's not necessary, though. If you're not comfortable doing that, that's fine. But it's just helpful for those listening to know, who the stakeholders are and all that. So, just wanted to reiterate, if that's something you're not fully comfortable with, don't feel compelled. Thank you. With that, Ms. Dittmer.
Stephanie Dittmer would like to make a comment. Go ahead, Ms. Dittmer.
My name is Dr. Stephanie Dittmer. I would like to make a comment regarding the 3.0 agenda item, other items not on this current agenda. I wanted to specifically call to attention my concerns about the draft language that was submitted and proposed. It is incomplete. There are unfinished sentences. There are fill-in-the-blank sentences, and there are sections that do not actually stick with the intent of the law. I'm concerned that the process that has been underway with the Nurse Practitioner Advisory Committee has not allowed for the ensuring patient safety and public safety. I think the draft regulations that were submitted are lacking any robust input and really, unfortunately, feels like the committee is simply trying to move things along instead of taking their jobs seriously in this task. It is rather disappointing. There's no mention of the importance of mentorship, of education, and the future agenda items should probably include things that have the ability for more robust regulation agencies and experienced lawmakers to be able to help with this process. Thank you.
Board moderator, are you able to have any of the other people make public comment, or is there a glitch?
Hughes, I was asked to be unmuted because I wanted to make a public comment. I don't know if you're waiting for me.
Go ahead.
Okay, thanks. Hi, my name is Catherine Hughes, and I'm a registered nurse and the executive director of the Nurse Alliance of SEIU California. We represent about 35,000 registered nurses, a few thousand of which are nurse practitioners. We did submit a letter to the BRN board members and Loretta, the executive officer, just right before this meeting. I noticed on the agenda that it said 101C, and I wanted to make a quick comment on 101. So if it's just 101, then I'll wait. Otherwise, I just wanted to let everyone know that we had submitted a letter. So is it on 101 in general and not just specifically 101 section C?
101 is the transition to practice, 101C. Are you wanting to make a comment other than the 101C transition to practice?
Right, just really quickly, we agreed with the the NPAC's recommendation that it would include a clause allowing nurse practitioners with experience to utilize previous practice experience, that we recognize that 101 is intended to apply to new grads. Thank you.
Marco Lizarraga would like to make a comment. 1 second, please. Go ahead, Mr. Lizarraga.
Okay, my name is Marco Lizarraga, and I am calling on behalf of La Cooperativa Campesina, Produce and Center for Employment and Training, which are some of my organizations that covered the statewide, serving primarily farm workers and rural working poor. We ask that our suggestions are incorporated into regulations. None of our suggestions for the regulations have been included. Currently, you are placing all the burden on patients that are Spanish speakers and many times have minimal education. A Spanish speaker will likely not know what letters next to a name mean. When patients come in through the door of a small or medium medical practice, they should be informed in writing what they are not seeing is a doctor. The regulations that you have released do not protect low-income patients that are in rural parts of California. Patients should know what services nurse practitioners can provide and what procedures they are not authorized to do. La Cooperativa Campesina has been servicing patients for over 40 years. Many times regulations are passed without thinking of those communities that are most vulnerable because of their income status. The ANPAC has not taken our comments into consideration, and they also have not outreach to us after we have submitted our letters to staff. Thank you very much for allowing me to comment.
I have one question, if I may, on the written notice. Is that something different than what is specified in the law under 2837.103 E, where it says a nurse practitioner shall post a notice in a conspicuous location accessible to the public view that the nurse practitioner is regulated by the Board of Registered Nursing and that it shall include the board's telephone number? That's the same kind of posting that a physician would have in their office. And I just want to be clear if that's something additional or if that is in alignment with that.
I would definitely suggest something. When you're talking about especially the farm worker communities and the rural working poor, many of them are, in their large percentage are immigrants. A lot of them have limited, Spanish, English speaking capabilities. So a verbal explanation to them would be very adequate. On the average, our people have probably second or third grade reading levels in Mexico, not here. And so I think that would be very helpful.
Thank you.
You're welcome.
Thank you, Mr. Lizarraga.
Thank you.
Alejandro would like to make a comment. Go ahead, Alejandro. Alejandro, go ahead. Yes.
Okay, I thought I was unmuted. My name is Alejandro Solis, commenting on behalf of Los Amigos de la Comunidad Incorporated, a community-based organization serving low-income Californians and farm workers in the Imperial Valley. Our organization has submitted several letters, and I've commented several times at past MPAC committee hearings. None of our suggestions for the regulations have been included. We have been ignored by the MPAC board and staff. Currently, you are placing the burden on patients. It should not be the patient's obligation to know or remember the meaning of abbreviations after a nurse practitioner's name to determine whether they are seeing a doctor or a nurse practitioner. The proposed regulations that you have released do not protect patients. There's a need for clear and accurate disclosures from the NP to the patient about the services that they are and are not authorized to do. Los Amigos will be submitting comments on the proposed regulations that you released on Friday, which cannot be discussed today because the general public has not had sufficient time to process the language. The NPAC and BERN are basically rubber stamping these regulations. When the public is not presented with the appropriate care they rightfully deserve, we will make sure to remind you that you did not responsibly do your job in protecting patients. Thank you for the opportunity to provide comments.
Thank you, Alejandro. Dr. Marks would like to make a comment. 1 second, please. Go ahead, Dr. Mark.
Good morning, everyone. I would like to introduce myself. I'm an MD physician, and I have the honor to precept nurse practitioners for many schools. One of them is UCLA, for example. I volunteer for that job, so I'm not paid for it. And I do this as I deeply appreciate, and I can understand and attest to the great service our awesome California nurse practitioner provide to our communities. My work in precepting gave me exposure to different nurse practitioner programs, and one thing I could notice is the rigor and requirement of these programs differ from school to school. Some schools have more rigorous programs than others. Currently, the nurse practitioners practice under physician supervision. The current nurse practitioner training is structured in a way that assumes physician supervision. The board and committee must ensure that nurse practitioners have the training, experience, and competency to perform the function specified in the law without the standardized procedures or physician supervision. The draft regulations are currently drafted ensures none of this. In order to ensure patients receive safe and quality care, nurse practitioners need additional clinical practice experience in order to transition to practice without physician supervision. The regulations must provide for a way to accurately confirm these hours required in the law. I personally have difficulty as a preceptor and teacher for nurse practitioner facing the challenge of them recording these hours, and a lot of the times when I try to check against our clinic hours, and I find some discrepancies. So I'm looking at if this goes public and it is going to be on a large scale, how can we confirm these hours? Knowing that there is no formal training required. In addition, nurse practitioner competency must be tested. They must be able to demonstrate that they have the medical knowledge, clinical judgment, critical thinking, decision-making, care management to perform all the functions specified in the law without physician supervision. The examination should not simply be theoretical, but should include a practical clinical competence test to ensure the nurse practitioner ability to safely and competently perform the function specified in the law without physician supervision. I feel like this will save all of us, including the medical board of nurses, from later on 10 years down the road from receiving a large number of complaints, or the nurse practitioners who will work independent.
Thank you, Ms. Marks. Margaret Parsons would like to make a comment. 1 second, please. Go ahead, Ms. Parsons. Ms. Parsons? Katrina Reyes would like to make a comment. 1 second, please. Go ahead, Ms. Reyes.
Hello?
Yes, ma'am.
Oh, can you hear me now?
We can.
Okay, thank you. Good afternoon, Katrina Reyes with the California Academy of Family Physicians. For future agenda items, we urge that the committee be given the opportunity to fully discuss and amend the draft regulations prior to it being presented to the board. Regulations are promulgated to implement, interpret, or make specific the law. Unfortunately, these draft regulations do neither of these. In fact, the draft regulations simply attempt to restate the statute, but does so in a way that is inconsistent with the new law. For instance, the draft regulations define transition to practice as 4,600 hours or 3 full-time equivalent years of clinical practice experience. This definition omits the term additional prior to clinical practice experience, as well as the term mentorship, which are both specified in the statute. Only using clinical practice experience rather than additional clinical practice experience and mentorship changes the meaning of the statute, that it implies that existing clinical experience rather than additional experience is sufficient. And when determining whether a rulemaking agency has exercised its authority within the bounds established by statutes, court applies a standard in which regulations that alter or amend a statute or enlarge or impair its scope are void. Another example of where the draft regulations are inconsistent with the statute is in the requirement that a Section 104 NP practice as an NP in good standing for at least 3 full-time equivalent years or 4,600 hours. The statute states 3 years, not full-time equivalent years, which is a very different time frame. The authority that was given to the board was to define the minimum standards for transition to practice. These bare-bone draft regulations provide no standard whatsoever, and thus does nothing to ensure that the new law is implemented in a way that will successfully achieve the board's mission to protect California's healthcare consumers and promote quality nursing care. There are also areas in the new law that necessitate the board to adopt regulations in order to implement, interpret, and make specific certain provisions, such as further clarifying the scope of functions, oversight enforcement of referrals and consultations, and consumer protections. Again, these draft regulations provide no guidance on how the new law is to be implemented. We submitted a detailed comment letter on what we urged the board to include in the regulations. CFP is concerned that these draft regulations fail to adequately implement the law and that no time has been provided to the committee to review and provide feedback prior to the November board meeting. As such, we urge the committee to take the time to draft meaningful and robust regulations that will protect California's healthcare consumers and promote quality nursing care. Thank you.
Thank you, Ms. Reyes. Joey Kachula would like to speak. 1 second, please. Go ahead, sir. Mr. Kachula, would you like to speak? Thank you, Mr. Kachula. Margaret Parsons, would you like to speak? 1 second, please. Sorry. Board Executive Officer Melby, there are no other requests for public comment. Would you like me to close this window?
Yes, please. Thank you, Mark. Okay, agenda 4.0 is just some opening remarks. So there is an agenda item summary in our packet for you guys to review. It basically sets ground rules. And so we're inviting healthcare professionals, stakeholders, consumers, and interested members of the public to attend and participate. We are doing this for the purpose of sharing information and seeking input. I can't even say that word today. I'm so sorry. No action will be taken at this meeting. It is just for sharing and participating. And the following is a listing of the meeting leaders. We did introduce all of ourselves at the very beginning when we opened up. And Reza did go over some ground rules. We'll reiterate them now. When you speak, please state your name and the organization, the community that you represent. It is not required in a public meeting, but it is helpful to know who is speaking as well as who they represent within the community. Everyone is encouraged to participate and no person should dominate a discussion. Listen and be respectful to other points of views. Do your best to understand the pros and cons of every option, not just those you prefer, and be as objective and fair-minded as you can be. And when you speak, be purposeful and to the point. The purpose is to hear many points of view and explore many options and solutions. This is a discussion, not a debate. We did include at the beginning of page 31 in our materials several letters that were received. As noted in the public comments, we did receive some additional letters received today and yesterday that did not meet the cutoff for posting, but will be posted in the subsequent meeting materials for the next upcoming scheduled Nurse Practitioner Advisory Committee and when this will go to the board. So we will make sure that those are included. They just didn't get included in this round. Additionally, in the comment section, please be respectful of everybody. I know that our board moderator is working hard to manage that. And as we always ask, that we will be respectful, and I'm hoping that the people that are doing public comments will additionally be respectful. Not everybody is familiar with certain terms. And so if they mispronounce your name or do not give you appropriate title, please just gently redirect them. That my board moderator is never intending to insult anybody. And because this is an agenda item, board moderator, we will open this up to public comment, please.
We will be opening for public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." David Turka would like to make a comment. Go ahead, Mr. Turka.
I'm an emergency physician. I work at Kaiser Permanente, Sacramento. I also work at Roseville, and I'm on the board of directors for California American College of Emergency Physicians. I really had 3 points that I wanted to make, and I had some concerns about the draft regulation. The first being the transition to practice, and really the number of hours and the experience for transition to practice, specifically delineating some more specificity for the emergency department, saying that there is acute care practice could include urgent care, which is very different from emergency medicine practice. The second point is along those lines, which is the procedural competency and a specific number of procedures that to practice independently in the emergency department. I'd like to see that further delineated in the regulations. And then the third is the attestation by a board certified emergency physician to sign off on nurse practitioner independent practice. The current regulations don't delineate that, and so they could be signed off by a peer provider or another nurse practitioner. Thanks very much for the opportunity to speak.
Thank you, Mr. Turka. Board Executive Officer Melby, there are no other public requests for comment. Oh, I'm sorry. Margaret Parsons would like to speak. 1 second, please. Go ahead, Ms. Parsons.
Other chance to speak. I just would like to thank the board for continuing to work towards thoughtful process on the NPAC issues. I'm a physician here in Sacramento and wanting to make sure we protect and have patient safety. I think it's important as the NPAC continues at work to really look at the recommendations that hopefully will be expanded on in the draft. Some of the issues of concern that are not yet fully elucidated would be really good transition to practice minimum standards. There's discussion of mentorship. What does that referral process for the 103 NPs look like? Clearer guidelines on the consultations for the 104 NPs. And then concern about the naming and how we define the names. The language has the to be thought about. And I have concern about the wording of independent nurse practitioners. The 104 NPs is what the law is setting out for them. And I think it's important as we move forward to have an understanding for our patients to understand who is caring for them and really having that be disclosed and notified as we all in medicine have to post it for MDs, PAs, and everyone has to do it. So really making sure that patients understand the different levels of care, as well as really developing what training and transition to get people from the experience they've had as nurse practitioners to get that extra training and build up the different experiences they'll need to be practicing more independently of physician supervision, and that they have that extra training about managing that panel and have the experience and supervision while they get that extra training. So I look forward to the board's development of strengthening the wording and expanding on the wording to give us all clear guidelines as we move forward. A second issue is I think it's important that we make sure that we understand what are the certifying bodies. In my experience within my specialty and working on the membership level, we found some people that had taken boards that were really not the standard to which your current nurse practitioner boards have, that we experienced in our specialties in medicine. I think it's important that the board really define a process that we vet what those certifying NP boards are. While the two now have good standards, I'm concerned that as things move forward, we'll have a little bit more fly-by-night activity. And I want to make sure the board really protects patients by establishing good standards of what those boards and how the BRN will approve the board's certifying process for the NPs. I thank you for the opportunity to speak today. I'm available anytime if I can be of any assistance, and thank you all.
Thank you, Dr. Parsons. Lino Bastida would like to speak. 1 second, please. Go ahead. Sandra Hernandez would like to speak. 1, please. Go ahead, Ms. Hernandez.
Estoy llamando de parte de Unión de Guatemaltecos Emigrantes. Nuestra organización ha enviado varias cartas y hemos comentado varias veces en audiencias pasadas del comité de NPAC. Creemos que no debe depender del paciente saber o recordar el significado de las letras después del nombre del enfermero y averiguar si está viendo a un médico o a un enfermero. Las regulaciones que han publicado no protegen a los pacientes. Los pacientes deben ser informados sobre los servicios para los que están o no están autorizados a realizar los enfermeros. Creemos firmemente que un aviso verbal no es suficiente para que un paciente sepa que no está recibiendo servicios de un médico. Creemos que las regulaciones deben requerir una notificación por escrito y una publicación en cada lugar donde la enfermera practicante ejerza, en un área probablemente que sea vista por todas las personas que ingresan a la oficina. La notificación por escrito debe estar en un idioma comprensible para el paciente. Nuestras comunidades necesitan estar informadas y hasta hoy nuestras cartas y comentarios han sido ignorados y no es justo. Esperamos que ustedes empiecen a trabajar para el pueblo y escuchen nuestras peticiones. Gracias.
Thank you, Ms. Hernandez. Lino Bastida, I'm going to try you again. 1 second, please. Go ahead, Mr. Bastida. Okay, I'm sorry. Joseph Kachula would like to speak. 1 second, please. Go ahead, Mr. Kachula.
Kachula with the California Medical Association. We've reviewed the draft regulations implementing AB 890 and have a number of concerns. The first is that the BRN does not have the legal authority to promulgate many of the provisions in the draft regulations. For instance, AB 890 defines transition to practice as additional clinical experience and mentorship provided to prepare an NP to practice independently, and includes a number of components that must be included in the transition to practice. The definition of transition to practice in the draft regs omits essential elements of that definition contained in the statute, specifically that the transition to practice be comprised of additional clinical experience, and that the transition to practice contains 2 component requirements: clinical experience and mentorship. The legislature provided a clear definition of transition to practice in AB 890. This definition enshrines their intent for the transition to practice requirement in no unclear terms. AB 890 tasks the BRN with establishing the transition to practice's minimum standards, not redefining it altogether. Neither Government Code Section 11342.2 nor existing case law allows the BRN to select certain elements of a statutory definition and disregard others when promulgating regulations. Fidelity to the entire definition in the statute is necessary to protect patients and ensure high quality of care. We are also concerned that the BRN has disregarded the requirements in AB 890 that requires the NPAC to advise and make recommendations to the board on all matters relating to nurse practitioners. The draft regulations contain numerous placeholders and ellipses that indicate that the BRN intends to add language to the draft regulations. Given the sheer volume of provisions in AB 890 not addressed in the draft regulations, such as language clarifying the consultation and referral requirements for 104 NPs and the allowable working arrangements for 103s and 104s under the corporate bar, there is the potential that what the BRN has posted here is but a small fraction of the regs which will be going to the BRN for consideration. It would be antithetical to the plain language of the statute, to public policy, and to sound patient safety to disallow the NPAC to consider and provide meaningful input on these matters and any others for which the BRN intends to promulgate regulations, either during this meeting or within a reasonable timeframe that allows the NPAC members to exercise due diligence in reviewing and considering draft regulations and to ask clarifying questions. Thank you.
Thank you, Mr. Kachula. Stakeholder would like to make a comment. A statement here would be that when I call you to make your comment, I'm pressing a button and a pop-up will pop up on your side that says you're allowed to unmute, just in case you guys are disconnecting yourselves. 1 second, stakeholder.
Just really quick, just to interject, and Reza, this might be the same thing. I was just going to ask you, actually, if we wanted to continue with this public comment. It is not pertinent to the agenda item. The agenda item was ground rules, and it looks like a lot of these comments are other types. And so I was going to look to your direction on how you wanted to proceed.
Sure. Yeah, I mentioned earlier, I think it would be helpful if we kind of stuck to the agenda as far as making comments pertaining to, for example, section 2837.101 or .103 or 104 at the time that those agenda items come up. That said, my recommendation would be to just go ahead and continue in case anyone does have anything related to agenda item 4.0. for those making comments, it is helpful to, for the sake of the meeting being organized and discussing the right thing at the right time, to kind of reserve your comments for the time that particular agenda item comes up. But nevertheless, I think we're all here to get as much input as we can. So I would suggest going ahead and allowing it to continue. The second thing I just wanted to confirm with our moderator is it the case that when you unmute somebody who's requested to make public comment, that they on their end have to actively unmute themselves by clicking the mute unmute button? Is that right?
Correct. I click on their name and it says request to unmute sent. And then on their side, they should get a pop-up that says unmute yourself.
Okay, so for those members of the public on the line, please keep that in mind. Once you are called upon to speak, you will have to take that affirmative step of unmuting yourself so that we can hear you.
Board moderator, can you let me know how many more public comments are in queue for agenda item 4.0, opening remarks?
Just 2.
Okay, we will take these 2 public comments and then we will go on to the next agenda item. Thank you.
Stakeholder, I am enabling you to, or sending you your request to make your comment.
Hear me?
Yes, thank you.
Yes, I'd like to appreciate the comment of the Spanish speaker that gave some sentiment regarding this topic. And I would just like to say that not being educated on the scope of practice that a nurse practitioner provides does not equate to unsafe practice, although I agree that there should be information about nurse practitioners, who they are and what they do in the language that's available to them. I think that's very important. And also a campaign to educate the public regarding us, which is the most important thing to do, especially if there's going to be access to care. Without nurse practitioners, my parents would be dead. So I don't appreciate this sentiment that just because we don't speak, like my parents don't speak English, they speak Spanish, that
Board moderator, I have lost audio. Was this person continuing to speak?
Stakeholder, are you still there?
No, I'm done.
No.
Oh, okay.
Okay, I'm sorry. Thank you, stakeholder.
Thank you.
Lino Bastida would like to make a comment. Go ahead, Mr. Bastida. Mr. Bastida, are you there? Board EO Melby, there are no other public requests for comment. Would you like me to close this window?
Please, thank you, board moderator. And we will go on to agenda item 5.0. Agenda item 5.0 is a discussion of minimum standards to transition to practice without standardized procedures as outlined in Business Professions Code 2837.101C. We will now open it up for the draft language review that was added to our materials section starting on page 17 of the materials package. You can scroll to there. When you do go to page 17 and you look at these sections, there are red font that says each one of these have been updated to include BPC sections 2837.101. There's also notations for the 103 and the 104 sections. Understand that the regulation that is in regular font that does not have a strike through or an underline is our current regulation that has been passed and is incorporated into our laws. So we will not be taking public comment on our current regulation that does not have a strike through or a underline. If you see a strike through on the draft language, that is language that is being either deleted or moved to a different area. And if you see an underline, that is language that has actually been inserted into our current regulation that is not underlined or strike through that specifically address the implementation of AB 890. So if you guys have questions or comments as we move through this process, please let me know. The sections 2837.101 in red will lead you to the sections that have the updates that are for this agenda item. And just a reminder again, if it's just regular font, that is our current regulation. We will not be taking any comment on that. That has already been passed and is our laws that we follow. Strike through is either moved or removed, and underline is the new content that has been added here for information sharing and responses and comment from you guys. So I will open this up to public comment, or I will not open up to public comment, sorry. I do want to open this up to have Reza, Heather, and Mariko provide information on what came with 101, why these changes were incorporated, and just give you a basic background on this process. And then once they have all presented on section 101, then we will open it up to public comment. Thank you.
This is Reza, Board Counsel. I think perhaps Heather and Mariko are better situated to speak about the draft and everything, but I just wanted to make one suggestion bouncing off of what you just said, Lori. I would suggest, I think it's super helpful to clarify what folks are looking at as far as the normal font versus the text that's in either strike through or underlined formatting. I would suggest if folks do have a comment about something that's in the normal font, that they be allowed to go ahead and make that comment. I think what you were trying to clarify, though, was an important point, just so there's an understanding of what all that is. Again, what's in normal font there that's not in underline or strike through is part of the regulations that have been on the books for a very long time prior to AB 890 being passed or really even proposed. So those are existing regulations that are not being proposed to be modified here. Again, I think if you have comments about that tie into the implementation of AB 890, that's fine. But what you see there in underline and strike through is really what's proposed to be changed in order to implement AB 890. I just wanted to make that.
Reza. Yeah, that's much more clear. Thank you very much. So I will reiterate on 2837.101C, which is the agenda item here. The specific statement says, transition to practice means additional clinical experience and mentorship provided to prepare a nurse practitioner to practice independently. Transition to practice includes, but is not limited to, managing a panel of patients, working in a complex healthcare setting, interpersonal communication, interpersonal collaboration, and team-based care, professionalism and business management of practice. The board shall, by regulation, define the minimum standards of transition of practice. The clinical experience may include experience obtained before January 1, 2021, if the experience meets the requirements established by the board. That context there with that final statement that says clinical experience may include experience obtained before January 1, 2021 is that grandfather clause that some people are making comment about that was written into this law to allow the board to take that into consideration. But the direction here that was given to the board is to establish by regulation minimum standards of transition to practice. And that is what has been attempted to be started with this draft regulation. And I'll open it up to Heather Hoganson and Mariko.
On these regulations is just because the statutes have gone in a certain direction does not necessarily mean the regulations need to. And so they are kind of interwoven, which is why staff is highlighting in red those sections of statute that the regulations are directed to. So for instance, the transition to practice on page 8 of the text, there are these minimum standards listed. And so that's what we want to hear from you on in terms of, you know, what is written here, what is missing, what is over, what is under. That's the sort of input we're seeking at this moment. And if you have other things that you think should have been listed with regard to 101 transition to practice, that's what we want to hear from.
Thank you, Heather. To start off with page 18 of our packet, but it's page 1 of the rulemaking information here, is 1480. That is our section of regulation that is currently there in place that has definitions. And what you can see that was added to that definition section to address the implementation of AB 890 is sections F to talk about different categories, G, clinical competent, H, clinical field related to nursing, K, the group setting, and under K is 1, 2, 3, 4, 5, and 6, which defines clinics, health facilities, additional facilities described in Chapter 2.5 of the Division 2 of Health and Safety Code, medical group practice, a home health agency, and a hospice. And then it skips down further to O, P, P1 and 2, and that is the only on definitions. So when you review that additional text, what you're looking at is the new text that it was inserted here to clarify any of the items included in AB 890 that may not be innately clear. And so we added that into the definitions section. 1481, we will discuss when we get to agenda item 103 and 104. And then 1482.3, that is updated to include sections 101 and 103. So we can definitely take some comments on those sections. And then 1482.4 again is for 103 and 104. Those will be addressed in a different agenda item. And the same with 1485.3, 1485.4. And so there are only 2 sections here that have specific language that address section 101. That is this agenda item. And so if we have no further comment with the panel here between our legal counsel and myself, I would like to open it up to public comment.
Sorry, we will be opening for public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for a comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Dr. Dittmer would like to make a comment. 1 second, please. Go ahead, Dr. Dittmer.
Yes, thank you very much. I would like to make a comment regarding this section here that has been introduced with definitions. The additional statements that have been added specifically regarding the clinical field relating to nursing, section H, and also the deletion of previous section B in primary care is inconsistent with the practice of medicine and within the structure of healthcare. The categories that have been chosen here, both previously in the unedited version, the original law, feel, again, like I stated earlier in my comment, that we have simply not done our job. The categories of nurse practitioners need to reflect the areas that they are going to be practicing in. The area of primary care, that is a comprehensive and continuous care across the lifespan, is duplicative and redundant, and again, does not show that the committee has done their due diligence to actually understand the areas in which nurse practitioners are being used, and again, do not really respect what the field of medicine is and how these areas have been created. This is not fair to the patients that we're supposed to be giving care to. It does not help clarify their needs, and upon the transition of practice, there is nothing that has been added to ensure there's been adequate amount of supervision and clinical practice experience. So though the definitions have been tried to delineate some of these statements, it is unfortunately failed in that regard. Thank you.
Thank you, Dr. Dittmer. Kathy Hughes would like to make a comment. 1 second, please.
Hughes, I'm a registered nurse with the Nurse Alliance of SEIU California, and I was just going to read what we submitted in our letter this morning. No additional requirements should be included in the transition to practice other than those defined in this section of the statute. The statute takes care to list the elements that should be included in a transition to practice, and these elements should be deemed sufficient to constitute a comprehensive transition to practice. Thank you.
Thank you, Ms. Hughes. Board Executive Officer Melby, there are no other public requests for comment. Would you like me to close this window?
Yes, I would. Thank you. I will check in with the legal team and see if you guys have any further discussions. And if not, we can move on to agenda item 6.0.
This is Reza, nothing from me at this time.
To point out that the primary care and the clinically field, those are just being moved to restructure. So those weren't actually changed from current law at this point. That's all.
Hi, this is Mariko. Just to build on what Heather said, the only change from current law that we're proposing in the definition section is the addition of the definition of group setting, which largely mirrors the statutory language in AB 890. Thank you.
Thank you. Yeah, this is Lori, the executive officer. I probably should have been more clear with that. With the strike through, it does not necessarily mean a deletion. It may mean that it was moved to for formatting or to accommodate flow of some sort. And so it will show as a strike through that it was deleted, and then it will show as underlined text as if it was inserted when in fact it has just been moved. We will see if there's a better way to kind of delineate that in our future meeting materials for both the NPAC and the board in November. Thank you for that input. So we will go ahead and move on to agenda item 6.0. Thank you, board moderator. Okay, agenda item 6.0 discusses the criteria that is outlined in Business Professions Code 2837.103. This has commonly been referred to as the 103 NP. This is the section that deals with when a nurse practitioner who has graduated from nurse practitioner academic institution, has become nationally certified, and has practiced for a minimum of 3 years or 4,600 hours, and has completed the transition to practice that has been established in 101. what they're allowed to do within specific healthcare settings. This is the section that talks about the nurse practitioner, that they are able to practice without standardized procedures, but that they are still practicing with other healthcare professionals as to have more of a collegial relationship with some shared input, that they are not necessarily on their own as an independent nurse practitioner, which we will discuss later in section 0.104. So just to provide some background on it, if you go to the 2837.103 and read the text, it starts with little a1 and will go down to 4CH, I believe, 4C6H. And it is all in there. This is also the one that we did receive some public comment on at the opening, where the concern is about the identifying themselves as a nurse practitioner. I can provide some input that I did receive from the Nurse Practitioner Advisory Committee subcommittee, as well as our regular team, is we did take into consideration what was written into the AB 890 law, where I will read where it says on 6D and E. So it says for 6D, a nurse practitioner shall verbally inform all new patients in a language understandable to the patient that a nurse practitioner is not a physician and surgeon. For purposes of Spanish language speakers, the nurse practitioner shall use the standardized phrase enfermera especializada. Then it goes to E, and it says a nurse practitioner shall post a notice in a conspicuous location accessible to the public view that a nurse practitioner is regulated by the Board of Registered Nursing. The notice shall include the board's telephone number and the internet website where the nurse practitioner license may be checked and complaints against the nurse practitioner may be made. For those purposes, we did have both a nurse practitioner and a medical doctor as part of the subcommittee. We did have the medical doctor show us the signage that is posted in their office. And it looks to be very similar to what this ask is here as well. Additionally, this is the section that the BRN has jurisdiction over. Please keep in mind that the BRN is not the end all kind of overseer of this, that each clinic, each healthcare facility, surgery center, et cetera, has different regulatory standards that they have to meet as well, which may include additional signage. And so I wanted to give some of that background for you guys to have as additional information. I know that there is concern with public safety. That is also a concern of the BRN. So we are open to hearing public comment on this. I do want to give my legal team a time to speak and update on this. You will, and when I turn it over to them before we go to public comment. So just for reference again, in the committee meeting materials today, starting on page 17 is our regulatory language. We are now addressing section 103. You will see those changes again outlined in sections 1480. Another update you will see in red that captures 103 and 1481. Additionally, 103 was updated to 1482.3 and 1482.4. And then further in 1485.3. And so you will go to those bolded sections that have the red font next to them that says updated to include BPC sections 2837.103. That is the part that is used to delineate the 103 NP. And again, the underlined font is the addition to help address the implementation of 890, and any strike through font would be any deletions or moves that has occurred to accommodate this. Now we'll open up to the legal counsel on the line.
And Lori, I think you've captured the changes really well. As I said, we don't really know if certainly for members of the general public, no one is going to understand what 103 nurse practitioner means. So if there are thoughts of what that level of nurse practitioner should be called, that would be great to put in the regulations. And any other things that, as you go through and you look specific to 103, if you have comments, that would be great at this point. Thanks.
Thank you. And then just a clarification that kind of talks about how the board has approached this rulemaking. In sections 103, it specifically said the board shall by regulation define. And so that was direction to the board from the legislative staff. The legislators. When you get to section 103, there is no specific direction that says the board shall by regulation define or do anything. So when our committee looked at 103, they looked at any of the writings within 103 to see if within the jurisdiction of the BRN, there was any additional information that needed to be included. And so these are the sections that were updated based on the input from the Nurse Practitioner Advisory Committee subcommittee that is focusing specifically on 103. And just so that all of the stakeholders here are aware, these subcommittees contain 2 people, and our 101 subcommittee was a MD and an NP. The 103 subcommittee is an MD and an NP. And the 104 subcommittee was our public member and an NP, so that there would be equal representation from both sides and input received equally. Thank you for that. And we will open it up to public comment. Board moderator. Real quick again, sorry to interrupt, board moderator. There is an attendee that does raise his hand. I just want to make sure that that attendee knows that the public comment period is where these discussions should happen. We are not able to address hand raising. So when we do open it up to public comment, please enter in the public comment section. I would like to make a public comment. Thank you very much.
Public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give reminders as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Scott would like to make a comment. 1 second, please. Go ahead, Scott.
Good afternoon. Can you hear me all right?
Yes, sir. Go ahead.
Good afternoon. My name is Scott Shelp. I'm a registered nurse. Apologies if my brief comment is slightly off topic, but I think this is the section this applies to. The point about public confusion about who's providing their care, NP or MD, this has been an issue really since nurses stopped wearing white. The requirement that everyone in hospitals wear name tags with nurse or doctor in large print has been helpful. I'm not sure if this rule applies to clinics or private practices. I don't believe that it does. I see that an effort has been made in the legislature in BPC, this 103.6D, which requires NPs to tell their patients that they are an NP and not a physician. I might add that the Spanish term enfermera especializada is feminine, and I know we men are in a minority in nursing, but enfermero especializado should be included as well. As we approach 2023 and the change in nursing in NP practice authority, this might be a good time to launch a public education campaign letting people know about the difference in healthcare providers, MDs, NPs, PAs. This could be a collaborative effort between the BRN and the State Medical Board and even the Physician Assistant Board. And as for the 103 NP question, how about NPI for independent? just a suggestion. Thank you.
Thank you for that suggestion. We will, just as a side note, I believe we're going to be doing a social media and an email blast to ask for input on the naming conventions for the 103 NP as well as the 104 NP. We do agree with our legal counsel, Heather Hoganson, on here, who 10 years from now, I don't think we want to refer to the NPs as 103 and 104 NPs. The general public may not have any idea what that means. So we do want to do that. There is a separate BPC code that we do follow within our Nurse Practice Act that does require specific identification on name badges to identify yourself. So I do want to let you know that we do support that, and we do want to have clear identification of which provider is providing what care to the individual.
Dr. Dittmer would like to make a comment. 1 second, please. Go ahead, Dr. Dittmer.
Thank you. In regards to the proposed language of 1482.3, the transition to practice and the requirements delineated in the BPC 2837.103, I was rather disappointed by the missing words of "in addition" following the category number 3. This is completely inconsistent with the original intention of the law. Additionally, by definition, there is no nurse practitioner that is currently practicing independently. Therefore, we cannot include those clinical hours in this draft regulation. The so-called grandfather clause, again, does not do due diligence or justice to the fact that the current educational and clinical standards are not standardized, and there is no independent practice of nurse practitioners. Likewise, under the additional term B under page 8 of 10 of the draft regulations, where it mentions the completion of this transition to practice can be submitted by an independent nurse practitioner. Again, this should not be allowed, as that is not part of what is currently in place. And I understand that we're trying to create a forward-thinking document, but again, this is somewhat, quote, experimental. And if we're going to hold patient safety as the primary source of information, we must do so using the standard of our current medical practices. Additionally, under the section 2, under the section 9, page 9 of 10, the full-time equivalent, or 4,600 hours, is nowhere near the equivalent amount. It's usually about a third to a fourth of the amount of hours that we require our physicians to practice independently. Again, I state that I do not think the transition of practice that has been created by the board and NPAC committee is sufficient for patient safety, and it's rather disappointing, and it should be taken back and started over with additional help. None of the practice recommendations have been taken into account, and I would strongly encourage you to do so. Thank you.
Thank you, Dr. Dittmer. Amy Ziegler.
Moderator, before we move on to the next one, I would like to do a quick education section for our stakeholders on here. When a nurse practitioner graduates from a nurse practitioner education institution in California, there are 3 ways that they can become a nurse practitioner in the state of California. One is through graduating from a board-approved school. Number 2 is from having national certification. And number 3 is through an equivalency where they get a review. That nurse practitioner now and going forward on initial licensure will always operate under standardized procedures. That has not changed with the implementation of AB 890. Only once the transition to practice has been completed, including 3 years to 4,600 hours, which was not made by the Board of Registered Nursing. That was in statute that the legislator passed. So we do have to follow that 3 hours and 4,600 hours on 3 years or 4,600 hours. Sorry, I'll try to clarify that. Only at that point will that nurse practitioner be able to operate in specific healthcare organizations with other healthcare providers, not in their own independent practice. Then once that has occurred, once the transition of practice, once that nurse practitioner has operated for 3 years at minimum under standardized procedures with a physician oversight at that point, would they be able to do this transition to practice and operate as a 103 NP? When they're operating as that 103 NP, they were then, after they complete those 3 years, unless the board and the committee decides to change that time frame for DNP prepared NPs only, would they have to operate in that setting for an additional 3 years. So just so that the stakeholders are aware of, these NPs will not be new grads. They will be at a minimum 3 years operating under standardized procedures, operating with a physician oversight before they can complete this transition to practice to go into be operating as a 103 NP. And then during that time frame, they will have to complete 3 years in good standing as a 103 NP before they can move to a 104, which is what people are commonly identifying the 104 as an independent NP. So please bear in mind that these NPs will be operating for 6 years before they can move towards that. This is a path forward. This is a process to get to independent practice, that nobody will be granted independent practice immediately upon the passage of this. So I just wanted to provide that education so that everybody on the call is clear with the process that our legislator has laid out for us in law, that the BRN is trying to draft regulation to assist. Board moderator, you can go on to the next public comment.
Amy Ziegler would like to make a comment. 1 second, please. Go ahead, Ms. Ziegler.
Can you hear me?
Yes, we can, ma'am.
Thank you very much. My name is Amy Ziegler. I am an advanced practice provider manager for Stanford Healthcare. And maybe after my comment, Loretta Melby can maybe make some clarifications, but I do have concern under section 1482.3 when it comes down to capital letter A. For the purposes of this subsection, transition to practice means 4,600 hours or 3 full-time year equivalent years of clinical practice that are all of the following. My biggest concern is the one that they are completed in California. As a hiring manager for Stanford Healthcare, as I've also practiced other places and hired nurse practitioners, this may be a significant barrier to hiring nurse practitioners from out of state, if this is going to stop them from practicing as a 103 NP here in the state of California unless they complete this transition to practice or 4,600 hours. If they've practiced for 8 or maybe even 10 years more outside of California, which could be a barrier to those of us who hire and bring on nurse practitioners from out of state. Thank you for allowing me to make public comment.
Thank you for allowing me to respond. I'm actually going to bring in Reza on this. There was a section in the law that was passed that talks about a transition of practice that has to be completed in California. And that is why this was carried over here. Reza, if you don't have that on the top of your head, that's okay. I'm looking for that in the language right now. But if you could help me out, that'd be great. Perfect.
Yeah. Thank you for the comment. The subdivision that you ought to take a look at is section Business and Professions Code, section 2837.103, subdivision A1D. That's little a1D. And what that says is it lists the requirements to practice under 103 without standardized procedures. Subdivision D says, has completed a transition to practice in California of a minimum of 3 full-time equivalent years of practice or 4,600 hours, end quote. So I do see the point that the commenter was making about, the concern of that potentially being a barrier. Unfortunately, it's in the statutory text, something that we don't have control over at the BRN, where it says has completed a transition to practice in California. So I'm really not sure of another way to interpret that or deal with it that it eliminates that issue. So that is, again, 2837.103 subdivision A1D, where that requirement is coming from. It's not something that the BRN has decided to add in as an additional layer via the regulations that we do have control over.
Thank you, Reza. So yeah, just to be clear, we did have to insert the sections in California because that was what was passed in law. So it's not the BRN trying to impose a block or a delay. That is what was passed into law. I can let the stakeholders know that there is an assembly bill right now that's been introduced by Assemblymember Wood, February 17th, 2021. It is a 2-year bill and it is number 852. And that is the nurse practitioner scope of practice, practice without standardized procedures, and it's commonly referred to as a cleanup bill. So if you did have specific input on the statutory sections that have been outlined in legislation that the BRN cannot change by writing regulation, if you feel that those are incredibly important and something that absolutely has to be addressed, I would encourage you to reach out to Assemblymember Wood's team and talk to them about changing that or adding that into the cleanup bill, Assembly Bill 852. Thank you.
Cynthia Yovanov would like to make a comment. 1 second, please. Go ahead, Ms. Yovanov. Yes, ma'am, we can. Thank you.
Oh, perfect. Thank you for all the great updates. I actually wanted to point out on page 23 of the draft section, I think we need a little more clarification on 1481 103 category in relation to section B, C, and D. It's a little confusing to be identified as an APRN because an APRN by definition includes a CRNA, CNS, midwife. I think historically we've been identified as a nurse practitioner, and I would recommend that we stay that. And there is a bit confusion if we move forward with this title or the ability to use these letterings in combination of our national board certification. We cannot hold out as a nurse practitioner until we obviously finish our schooling, but we also cannot bill until we actually have a national board certification. Based on the national board certification you take, identifies our lettering. So I have a bit of an issue that this may create future complication for those of us that need to get credentialed in big hospital systems. I think that being identified as an APRN encompasses too many of the APRN titles, and having certified nurse practitioner to say that we're certified by the Board of Nursing versus the national board that declares us to bill through CMS. That would be my only recommendation, is to maybe think beyond those letterings. Thank you.
Thank you, Ms. Yovanov. Nancy Trago would like to make a comment. 1 second, please. Go ahead, Ms. Trago.
I'm a geriatric nurse practitioner, and I work for Kaiser Permanente in Napa. I'd like to thank the board and Impact for the very important work they're doing to implement AB 890. But by definition, since I work at Kaiser, for the purposes of this discussion, I'm a 103 NP because I work in an organized group setting. I also represent CANP, and we do not agree with Impact's recommendation to adopt an attestation of supervision form for the 103 MPs. Nor do we agree with the clinical competency committee to be required to attest to the competency of an NP to practice. Since we work in an organized group setting. We have already in place vigorous annual peer reviews and recredentialing processes. So I just wanted to remind the board that the 103 NPs should not be required for extra attestation of supervision forms. Thank you very much.
So to the last commenter, you said that there should not be, in your opinion, an attestation form to document the 4,600 hour transition to practice period. I think that's what was said, and please correct me if I'm wrong. Do you happen to have a recommendation of how the board would be able to discern whether an individual has completed the statutory mandated transition to practice, short of some type of attestation or some type of documentation? I'm at a loss to see how the board would have any idea whether someone has completed that transition to practice. So if you have a recommendation or a proposal, that would be great. If not, that's fine too, but your comment is noted either way.
She able to unmute and respond if she chooses to?
Oh.
There she is.
Yes, I can make a response by simply having completed 3 years of practice in an organized group setting, such as Kaiser Permanente, for instance. That would be enough to show that there's adequate experience that has been completed, clinical experience.
How would you recommend providing that documentation to the board so that we would be able to validate that and update your license to reflect that you have completed the 103 section?
Well, I envision that would be part of the application process in renewing the license through the BRN as a 103 NP.
Sorry, Reza, I was actually staring at your video to see if you had froze or not, but it looks like you're moving. Thank you for that comment. I think that we're kind of speaking the same kind of process here. So if you were to apply for the 103, that nurse practitioner applying would then attest that they have worked in that setting. But you're wanting that attestation to not be a separate document, but you would want that attestation to be part of the Breeze system where you would do the license renewal. Is that my understanding?
Yes, Loretta, that sounds perfect.
Thank you. We will definitely note that. Board moderator, you can go on to the next public comment.
Suzanne Phillips would like to make a comment. 1 second, please. Go ahead, Ms. Phillips.
Good afternoon. This is Suzanne Phillips. I am a professor at UC Irvine, and I'd like to make a comment on the on section 1481 C and D regarding the 103 and 104 nurse practitioners. I just wanted to make the comment that both 103 and 104 nurse practitioners are considered independent. One functions within a organized group setting according to the settings that are listed in statute. The other one works independently in their own business, with their own business. But since 103 NPs do function under their own scope of practice, they don't have to have standardized procedures, and there's a clause in the statute about the organization or entities cannot interfere with the professional judgment of a nurse practitioner. They are, in fact, independent. Of course, other types of healthcare providers are independent as well, but they do need to be credentialed and privileged in those settings. In the settings that are defined, at least. So that's the comment I wanted to make on this. I don't have an idea about what we would call these different NPs. And I wanted to also make the comment that APRN-CMP is already in regulation, I believe. That was changed some years ago, but we can still just use the acronym for nurse practitioner, which is NP. In terms of, that was specifically to the comment made on Section D. And that's it.
Thank you, Ms. Phillips. Margaret Parsons would like to make a comment. 1 second, please. Go ahead, Ms. Parsons.
I wanted to speak around, thank you. This is Margaret Parsons, a physician here in Sacramento. Wanted to speak to language around 1483, notification of the 103 NPs, but making no mention of the referrals that were referenced in 2837.103. So concerned that when a patient is beyond the scope and education of the training of the 103 NP, AB 890 requires that the 103 NPs refer that patient to a physician or surgeon. We really need the language to include referrals pursuant to a written agreement, that we have those agreements set up in writing in advance with physicians and surgeons and healthcare facilities. Patients need to know that they're safe and that there's a process of what will happen if something needs additional care and additional steps. I think it's very important that the language expand with written guidelines, talking about the types of conditions that might be outside of an NP's expertise and training, and really give clarity, transparency for the patients as well as the providers that will be helping to really keep that patient safe. Patients do have the right to receive upon request that there is that written agreement and the steps of how that referral will work as the nurse practitioner is working on those processes that they're authorized under this section. I really, really want to be sure that patients understand where their next steps in care can be, recognizing the NPs can bring so much to healthcare and helping take care of patients, but also making sure we have a clear understanding of what that referral process is, and that the nurse practitioners have those agreements with physicians and health facilities will understanding care. We as physicians have those in place for if we're doing certain procedures and we need to have an established relationship, the surgery center to the hospital or to a different consultant. And I really think it's important that as the code language and the regulatory language is developed, we have a clear understanding for the patients to know what the path might be, and that the physicians that might be assuming care know what may be coming their way. So I thank the NAPC and the Board of Nursing to really think, and PAC and the Board of Nursing to really think about expanding language to include these protocols and guidelines so that we all understand what the process should look like. And I thank you very much for the time you're putting into the thoughtfulness of how the regulatory language can be further expanded and developed for clarity. Thank you.
Thank you. Don Shinsky would like to make a comment. 1 second, please. Oh, I'm sorry. Don has dropped off. Kathy Hughes would like to make a comment.
Hi, this is Catherine Hughes, a registered nurse with the Nurse Alliance of SEIU California. We believe that once a 103 NP completes their transition to practice, there should be no additional application or specific recommendation by the BRN. We do not believe that an independent clinical competency review by committee or attestation by a physician or surgeon, 103 nurse practitioner, or an independent nurse practitioner be required to attest to the competency of an NP for them to practice independently. The completion of the required transition to practice should suffice, and no additional application to the BRN should be added. Thank you.
Thank you. Joseph Kachula would like to speak. 1 second, please, or would like to make a comment. I'm sorry. Go ahead, sir.
Kachula with the California Medical Association. The draft regulations contain a clause for existing NPs that would exempt them from the transition to practice period. While we previously commented both in writing and orally that this is beyond the BRN's legal authority, the practical effect of this is that 103 NPs could begin practicing sooner than the statute would have allowed. By definition, many of these NPs will practice in hospitals and other settings where NPs are typically and traditionally employed. However, AB 890 states that the prohibition on the corporate practice in medicine applies to both 103 and 104 NPs. This means that, like physicians, by law, the 103 and 104 NPs cannot be employed or controlled by lay entities. However, under AB 5, Assembly Bill 5, the operative worker classification law and its progeny, the NP is also prohibited from working as an independent contractor. So just to be clear, under existing law, 103 and 104 NPs can neither be employed due to the corporate bar nor hired as independent contractors under the work classification laws. Accordingly, it is imperative that the BRN provide guidance regarding corporate practice and medicine prohibition, allowable contracting arrangements, practice ownership and control, and employment arrangements for 103 and 104 NPs. Thank you.
Thank you. Naftali Navarez would like to make a comment. 1 second, please. Go ahead, Ms. Navarez.
I'm a rheumatologist.
I'm sorry.
This is Naftali Navarez. I'm a rheumatologist in Berkeley. I'd like to express my concern over the transition to practice requirements. Every NP currently practicing in California must do so under standardized procedures, so that any clinical experience a current NP possesses is by itself insufficient to satisfy the transition to practice requirement. My biggest concern is with patient safety. Physicians need 3 to 4 times the amount of clinical experience and must demonstrate a fund of knowledge to be able to practice medicine. 3 years of clinical experience for 4,000 hours does not come close to meeting that requirement. So the request to practice independently without even an attestation or some sort of clear demonstration of an adequate fund of knowledge by testing and certification and no real path to go about that is quite concerning to me. So I'm hoping that the board more clearly outlines the pathway to obtaining the proper certifications and how they're going to allow independent practice, and that I hope it's discouraged that simply having the 3 years of existent supervision should be sufficient to allow for an independent practice. Thank you.
Thank you, Mr. Navarez. Shake Hagnazarian would like to make a comment. 1 second, please. Go ahead.
I wanted to comment on the attestation part, which attestation to competency by a person who's supervising a nurse practitioner sometimes can be biased. So I don't think that 103 nurses, while they'll complete their transition to practice, there should be no need for attestation. And as far as application and how to determine if a nurse practitioner has done 3 years, as MPs and RNs, we have to renew our licenses every 2 years. So the board can clearly see the documentation and how many years this person has been an MP or an RN, and they can go about that. And as far as how to name the MPs, this is just a suggestion, but we have some companies such as County or even Kaiser has RN1, RN2, RN3, depending on their managerial role or how many years they've been in the practice. So I think MP3 and MP4 would be helpful as well. I don't know if we would need to have an MP 1 and 2, but MP3 and MP4 might be helpful. And that's it. Thank you for giving me the chance to comment.
Thank you. Board Executive Officer Melby, there are no other public requests for comments. Would you like me to close this window?
And then we can move on to the next agenda item. Thank you. The next agenda item is item 7.0. And this is discussion of the terms that were delineated out from BPC 2837.104. This is commonly referred to as the Section 104 NP. This is the one that in the statutory requirement put forth by the legislator says beginning January 1, 2023, notwithstanding any other law, the following apply to a nurse practitioner who holds an active certification issued by the board pursuant to subdivision B. In this section, it is kind of to refer back to 101, it said the board shall define by regulation. And then in 103, there was no direction by the legislator. In 104, it says that the board should address possibly the requirement for the nurse practitioner that holds a doctorate of nursing practice degree. And so what that states here, it says in C, has practiced as a nurse practitioner in good standing for at least 3 years, not inclusive of the transition of practice required pursuant to subparagraph D of paragraph 1 of subdivision A of section 2837.103. And this is where we can address, it specifically says the board may, at its discretion, lower this requirement for a nurse practitioner holding a doctorate of nursing practice degree, DNP, based on practice experience gained in the course of the doctoral education experience. And so that was the intent of the subcommittee here, to see if that was something that wanted to be addressed, because the board may at its discretion address it. And the language that was written again starts in the materials on page 17, and you will see it in the bold sections for 1480. It does state in the red next to that it addresses the subsection 2837.104. You can also go down to the next bold section that calls out 1481, and you can see in the red that it addresses subsection 0.104. The next area would be in the bold section, 1482.4, where it does address in the red, the section 104. And in the final section, it's 1485.4, scope of practice for the independent nurse practitioner, or 104. And this is updated as well. So this is where we've got the draft so far, and we welcome your feedback. I will open it up to the legal counsel that is in our panel to see if they have any additional items to speak to prior to opening up to public comment.
This is Reza. Nothing from me at this time.
From Heather, I think, Laura, you've covered it.
Thank you very much. Board moderator, you can open it up to public comment for the section 104 NPs from Business Professions Code 2837.104.
Excuse me. We will be opening for public comment now. We'll be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Nancy Trago would like to make a comment. 1 second, please. Go ahead.
Nancy Trigo again. I'm a geriatric nurse practitioner. I also have a doctorate of nursing practice degree, which by the nature of this degree, it is a clinically based nursing practice degree. So therefore, and as a representative of the California Association of Nurse Practitioners, I'd like to request that the number of years for the 104 NP to transition to practice, those requirements be reduced from 3 years to 1 year would be adequate. Thank you very much.
Thank you. Scott would like to make a comment. 1 second, please. Go ahead, Scott.
Thank you. Hello again. If I'm to understand this section correctly, we're giving credit for the practicum hours within the DNP education program. There are clinical hours for the master's program as well, which the legislature has not given, is not taking into consideration. In other words, the experience gained must be after graduation. So how is that different from the clinical hours in the DNP program? I'm assuming there are more, but if someone could educate me on why we give credit for essentially school hours for the DNP, but not for the MSN. Obviously, legislatively, we can't give credit for the MSN, but if someone could clarify that for me, Loretta or Reza, thank you.
So that, this is Loretta, the board's executive officer, or Lori. That was actually a very robust discussion within that subcommittee. And that is why the recommendation that came out of that subcommittee was not to decrease the requirement down to 1 year. They were not able to come to an agreement that that would be equitable and that it would make sense, because this is experience that was done within the education setting and not post-education. So the NP that did serve on that committee is a doctorally prepared NP. He provided a lot of information, a lot of evidence to that, and that was taken into consideration by the other subcommittee member and then presented to the Nurse Practitioner Advisory Committee for everybody's input prior to being recommended forward, that they decrease it hour per hour versus giving it a 1 year or 2 year off carte blanche. So that was definitely a consideration, and there was some conversation around that. And the decision that the committee decided to put forth was to do a hour for hour decrease for any clinical patient care clinical hours that the DNP had in over and above the minimum that is required for the master's prepared. So hopefully that answered your question and provided some clarification.
Kathy Hughes would like to make a comment. 1 second, please. Go ahead.
Hi, this is Catherine Hughes, registered nurse, the executive director of Nurse Alliance of SEIU California. We believe that nurse practitioners with a doctorate in nursing practice who are completing an additional transition needed to become a 104 NP should have their transition time decreased from 3 years to 1 year. The national standards for the American Association of Colleges of Nursing Essentials for DNP Education align with the spirit of AB 890 and provide evidence for reducing the number of years of practicing in good standing from 3 years to 1 year. Thank you.
Thank you. Board Executive Officer Melby, there are no other public requests for comment. Would you like me to close this window?
Yes, please. Thank you. And we can move on to the final agenda item. Prior to moving on to the final agenda item 8.0, I do want to make sure that the attendees and participants that are on this meeting are aware that we do have a nurse practitioner advisory committee that is scheduled to take place on November 16th. We will be presenting this regulatory language with feedback to that advisory committee. Please also note that the Nurse Practitioner Advisory Committee members have cleared their calendar and have been able to view this through the WebEx capability as not to violate Bagley-Keene, and that they were able to hear your comments, get your feedback, and hopefully this will help them to progress this regulation forward in a manner that can serve all and really look at the public protection aspect, staying in the realm of what the BRN actually has jurisdiction over, and taking into consideration that we cannot rewrite law, that we can only go by what law has been passed and with the passing of AB 890, and we can only draft the regulations that help to further clarify that specific law. So thank you guys so much. If everything goes well, we will present this language with your feedback to the Nurse Practitioner Advisory Committee in November, get final feedback from the Nurse Practitioner Advisory Committee at that point, and then present this language to our board. Once our board sees this language for the first time, they can then make a motion for us to start the regulatory process. Understand, and I'm going to call in Heather Hoganson to speak to this really quick, what the regulatory process then means. This is only the beginning. So these are all kind of preemptive to what is yet to come. So we've had these 2 stakeholder meetings in advance of even opening the regulatory process, which is pretty unusual. There are specific regulatory requirements that ask for public input and stakeholder input where we address. So those are still yet to come. So I'm going to open this up to Heather real quick so that she can talk about next steps once our committee is able to provide further input and our board is able to make the motion for us to move on the implementation of the regulatory package. Heather?
Thanks, Lori. So as Lori mentioned, this sort of additional outreach is in advance of the regulatory process. This is bonus rounds, and that we're doing in advance. Once the board has decided on some language, it will be sent through the director of the Department of Consumer Affairs and then to the Business Consumer Services and Housing Agency for their review. And then it will go out to formal public comment. There will be a 45-day comment period at which time people can submit written comments. They can also, anyone can request a hearing. And so we may have a hearing on these regulations that would be maybe in this format, maybe in a little slightly different format, depending on the state of everything at that time. And then should the board decide, based on all the comments received, either for or against, to modify any portion of the draft language, that language will also be sent out to anyone who either made a comment or who has requested to be on the mailing list. So if you're not already on the mailing list or you know someone who's interested, you might want to have them join the mailing list to get copies of that. And that's sort of a wash, rinse, repeat sort of thing, because that 15-day modified text, the modified text We'll have a 15-day comment period, at which time people can make comments, at which time the board can review those comments and decide whether or not they want to further modify the text. And then it would again have a 15-day comment period. And then when the board has decided that it's no longer needed to be modified in response to all those comments, the board will prepare a final statement of reasons to justify all parts of the regulation, and it will be sent again through the director and through the agency, and then to the Office of Administrative Law for their review of legal sufficiency and authority before it can become effective. So that's the regulatory process in a nutshell. But there are many places at which public participation is not only invited but encouraged.
Thank you, Heather. I know that that's important, just to kind of reiterate that and provide that education in as many of these forums as possible, so that everybody understands where we're at and why we're doing what we're doing. So currently these were information gathering sessions for us where we really wanted to hear from the stakeholders. This is our second one, in addition to, of course, all the public comments that happen within our nurse practitioner advisory committees. And so this again will be presented to our Nurse Practitioner Advisory Committee on November 16th. And then based on feedback from that Nurse Practitioner Advisory Committee, the plan is to present this regulatory language to the board on the November 17th and 18th board meeting, to include any information that was provided here, as well as any information that's provided from the Nurse Practitioner Advisory Committee. Understand that these are recorded, can be viewed by our board members at any point for review, so they will be able to see your comments and appreciate them and make a decision based on that receipt as well. And then once our board votes, and if they vote to move this regulatory package forward, we will then enter the official regulatory process. And that will be at least a year in the making, which is why we are hoping to get this passed and moved in November, so that we can have regulation promulgated by the time the requirements are set forth for the January 1, 2023 implementation for the 103 and 104 NPs. Additionally, OPES is a subsection that has to be completed prior to implementing those section 101. And OPES has a deadline as outlined in the legislation in the passing of AB 890 that says they need to complete their evaluation by January 1, 2023 as well. And we are looking forward to that input. They have quite a robust task ahead of them, and they are making good headway and talking with a bunch of experts. So thank you very much. We will move on to item 8.0. And item 8.0 is adjournment of the meeting. Thank you guys for coming and joining us today. I do see that we have about 66 people on here. Thank you very much for that feedback. And we will see you guys probably in a couple weeks at the November 16th Nurse Practitioner Advisory Committee meeting. Thank you. We are adjourned.